Welcome back, learner. You know we like to get into the details here right now. Well, today we are going deep, really deep, into a project that shines a light on an important issue.
Oh, yeah. This is a big one.
It really is. This project is all about documenting property rights violations by Turkey and seeking justice. That's the name of the project.
Straight to the point.
And it has led to a whole bunch of really detailed reports, and we're starting with the very first one, Systematic Violations of Property Rights by the State in Turkey's Series 1 Appointment of Trustees to Companies. Quite a mouthful, but pretty self-explanatory.
I was going to say, the title kind of lays it all out there.
It does, and that's exactly what we are going to be unpacking today, this whole idea of trustees being appointed to companies in Turkey. Specifically, we're looking at situations where there are alleged links to the Gülen Movement.
Yeah, that's the backdrop here.
We'll be diving into the legal arguments, the economic fallout, and really getting to grips with the questions of fairness and justice.
It's a complex situation, for sure.
So this report, it doesn't pull any punches. It really lays out a case arguing that these trustee appointments are systematically violating property rights.
And it goes deep into what are the mechanisms? How are they putting this into practice? And then what's the real-world impact on the businesses and the people involved?
It's not just theoretical. This is about real consequences. Okay, so let's set the stage a bit. The report points out that this practice of appointing trustees really picked up steam after 2014, becoming much more common around 2015.
Right.
So what was the reason, the official justification given for this sudden increase?
Basically, it all boils down to the Gülen Movement. The Turkish government considers it a terrorist organization, so they started cracking down on individuals and any companies they thought were connected.
And we're not talking about a small number of businesses here.
Yeah.
The report states that thousands of companies were placed under the control of these trustees. Thousands.
Yeah, it was a huge sweep. And think about the ripple effect. Operations disrupted, finances in turmoil, reputations tarnished. The impact was massive.
And that's really where the human rights argument comes in. The report goes beyond just the practical implications for businesses and frames this as a potential violation of fundamental human rights.
Right. The right to property, for one. This is a cornerstone of international law. It's enshrined in the Universal Declaration of Human Rights, the European Convention. These are foundational documents. And then there's also the whole question of due process, the right to a fair trial. Are these individuals and companies actually getting that? The report raises serious doubts.
Now, the report does acknowledge that there is a legal mechanism in place that allows for these trustee appointments. They point to Article 133 of the Code of Criminal Procedure. Could you break down what this article actually says and then maybe where the report sees potential problems or misapplications?
Sure. So Article 133 of the Code of Criminal Procedure, this is number 5271, by the way, enacted back in 2004. It essentially says that a judge or a court can appoint a trustee during an investigation or when someone is being prosecuted if there's strong suspicion of wrongdoing happening within a company and they believe a trustee is needed to get to the truth.
So there's a legal framework, but the question is, was it applied properly?
That's what the report digs into. It looks at how Article 133 was used in practice and compares that to the bigger picture of the law. One big issue is the difference between these trustee appointments and other legal measures. You've got things like confiscation or seizure, right? But those usually happen after conviction, after someone's found guilty. With trustee appointments, you're restricting property rights much earlier in the process, often before there's any definitive proof of guilt.
That's a big distinction. And the report argues that this isn't just a technicality. It goes to the heart of due process.
Exactly. You're basically taking control before the legal process is fully played out.
And even within Article 133 itself, there are specific conditions that have to be met. Did the report find situations where those conditions weren't being satisfied?
Oh, yeah. And that's a major point of contention. They found lots of cases where the report suggests that political factors were driving the decisions more than the actual evidence. A core issue was this idea of catalog crimes. You need evidence of an ongoing catalog crime happening within the company for the appointment to be lawful under the article.
So maybe we should pause for a second. Catalog crime, what exactly does that mean in this context?
So in Article 133, especially in its original form, catalog crimes referred to a very specific list of serious offenses. These were the offenses that could potentially justify trustee appointment. The report highlights that sometimes the alleged offenses like financing terrorism before the law was changed in 2016 weren't even on that list when the trustees were appointed.
So they're saying that the law was applied retroactively in some cases.
That's their argument. and it raises some serious legal concerns.
And what about the evidence itself? What kind of proof was being used to justify these appointments? The report seems to suggest that there were some real problems in that area, too.
Definitely. The report really criticizes the kind of evidence being used. For example, they talk about a prayer list found on company computers being presented as evidence of criminal activity. Or there's this one instance where a list of graduates from a certain year in a specific town was used. These are just a couple of examples. The report argues that this kind of evidence doesn't actually prove that a catalog crime was being committed by the company.
A prayer list. That does sound like a bit of a stretch to use as justification for taking over a company. And the report also brings up this idea of general confiscation being a problem. How did that factor into the trustee appointments?
They argue that in many instances, these trustee appointments were essentially acts of general confiscation. They were seizing all of the company's assets, even if there was no direct connection between those assets and any alleged crime.
Which is a big no-no in many legal systems.
Right, you can't just take everything. The principle of proportionality comes into play here. Any restriction on property rights has to be targeted and has to be justified by the suspected wrongdoing. Taking over the entire company and all its assets, that seems to go against that principle.
And they're saying that this lack of proportionality wasn't limited to just the legal arguments. It also extended to the real-world impact on the businesses and individuals.
Exactly. They argue that the burden placed on the owners, on the companies themselves, it was excessive. It went way beyond what could be justified, especially when you consider how weak the initial legal basis often was.
Let's shift gears a bit and talk about the Savings Deposit Insurance Fund, that's the SDIF. The report really highlights their role, especially during the state of emergency in Turkey. How did they get involved in all of this?
So, during the state of emergency, which was declared in 2016 and lasted until 2018, the SDIF's role in these trustee appointments changed dramatically. Before, courts were making decisions on a case-by-case basis. But then, with these emergency decree laws, they basically transferred the authority to appoint trustees to the SDIF for any companies considered to be linked to terrorist organizations. And increasingly, that included anyone accused of connections to the Gülen Movement.
So the SDIF became the main player in these cases.
Pretty much. They were the go-to for any new appointments related to these kinds of accusations. And their power grew, too. They got the authority to decide whether to sell or liquidate these seized companies, and they could do that even before any final judgment in court.
So you have a government-controlled entity deciding the fate of private companies, potentially even before they've been found guilty of anything. That does raise some eyebrows, to say the least. What did the report have to say about the SDIF's impartiality?
Yeah, that's a major red flag. The report is very concerned about whether the SDIF could actually be impartial. Their primary job is to protect depositors in the banking system, but now they're also managing all these companies, and the report argues that there's an inherent conflict there.
Because if their main responsibility is to the depositors, they might not be looking out for the best interest of the companies and their original owners.
Right. They might prioritize the depositors' needs over everything else.
And the report also brings up this idea of ministerial discretion. Basically, the minister in charge of the SDIF had a lot of say in whether to sell or liquidate these companies. Why was that seen as problematic?
It introduces this element of political influence into the process that raises questions about whether the decisions are consistent and predictable or if they're being made arbitrarily. And because it's the minister making these calls, there's less oversight, less accountability compared to the judicial system. So it makes it hard for the company owners to know what's going to happen and makes it much harder for them to challenge those decisions.
It sounds like the state of emergency really changed the game when it came to these trustee appointments. A lot more power concentrated in the hands of the SDIF with fewer checks and balances. But the report also points out that this wasn't just a temporary thing.
Exactly. The SDIF kept a lot of those powers even after the state of emergency officially ended. There were new laws passed that continued to give them broad authority in this area. And that's a really big concern because it suggests that these extraordinary measures have become normalized. They're just part of the system now. And what does that mean for property rights and the rule of law in Turkey?
Right. It's not just an emergency measure anymore. So let's dive into the economic impact. The report paints a pretty bleak picture of what happened to these companies once they were under the control of the trustees.
Oh, yeah. Financially, it was disaster for many of them. They saw a huge drop in asset value. The report gives an example. Companies under the SDIF's control, they had about $13.8 billion in assets in 2016. But by December of 2023, that number had plummeted to just 5.2 billion.
That is a massive loss. Over 60% of their value gone in just a few years. What caused that kind of decline? Was it all just mismanagement, or were there other factors at play?
It's probably a combination of things. There are definitely allegations of mismanagement by the trustees, but there's more to it than that. Companies were being forced into sale or liquidation, sometimes for way less than they were actually worth. The Surat cargo case is a good example of that. And just the fact that these companies were under trusteeship created a lot of instability and uncertainty, which scared off investors, disrupted business, and just generally eroded confidence in the market.
It sounds like a perfect storm of negative factors. And the report doesn't just look at the big picture. It also points out some specific irregularities in how the trustees themselves were appointed. What were some of the red flags they found?
There are several patterns that jump out. For one thing, you had a very small group of people being appointed as trustees for a huge number of companies. I mean, there are cases where individuals like Bülent Navruz or Emran Okumuş were each responsible for overseeing over 100 companies at the same time. How can anyone possibly manage that many businesses effectively, especially across different industries?
It does beg our belief that a handful of people could have the expertise to handle such a vast and diverse portfolio. What other irregularities did they uncover?
They found instances where the people being appointed had close ties to the government, or their backgrounds raised some serious questions. For instance, there was Ümit Önal, a trustee for some Kocaeli holding companies, who later became the CEO of Türk Telekom, a company with significant government involvement. Another example is Aytekin Karahan, appointed to Kanak Holding. He had been implicated in a public procurement fraud case. So it's not hard to see why people would be suspicious that these appointments weren't based on merit, but maybe more on political favoritism.
It certainly casts a shadow over the whole process when you see appointments like that. And there are also allegations that these companies weren't being managed with the goal of preserving their value, but were instead being treated as spoils. Can you elaborate on that a bit based on the report?
There's a case they highlight, the İhlalleri group, where after the trustees took over, they apparently increased the workforce significantly, but there wasn't any corresponding increase in business activity. And the company ended up racking up a ton of debt. They also quote people like Abdullah Güzeldülger, who was the chairman of Boydak Holding while it was under trusteeship. He claims that these companies were basically seen as prizes for people close to the government. And he even talks about being pressured to make deals that benefited those individuals. And the lack of transparency, the fact that nobody really knew what was going on inside these companies once the trustees took over, just fueled those suspicions.
And what about the original owners? What kind of rights did they have in all of this? Could they challenge anything, or were they just completely shut out?
The report found that the owners' rights were severely limited. They often couldn't get access to company records, they couldn't really monitor what the trustees were doing, and that made it even harder for them to challenge any decisions, which just added to this feeling of being unfairly treated and stripped of their property.
So let's talk about Kanak Holding. The report does a deep dive into this specific case. Why did they choose Kanak Holding as a case study?
Kanak Holding is interesting because it was one of the first big companies to be targeted, and this happened right after those corruption investigations in December 2013. They were seen as being connected to the Gülen Movement, and that made them a prime target.
And what was the evidence used against them? What did the authorities present as justification for appointing trustees to Kanak Holding?
So it all went down in November of 2015. A single judge made the decision to appoint trustees, and the main evidence they used was a police investigation report. The report lists some of the things that were included as evidence. And it's pretty astonishing. Things like a prayer list found on company computers, a list of graduates from a certain year in Trabzon, can you believe that?
Yeah.
Mentions of Fethullah Gülen by employees, and records of donations to organizations that were perfectly legal.
A prayer list? Seriously, that sounds incredibly flimsy as evidence for criminal activity, especially in a business context. The report really takes issue with the relevance of that kind of information, right?
They absolutely do. They argue that this kind of stuff doesn't actually prove that Kanak Holding or any of his companies were committing a catalog crime. And then they make another important point. These allegations of terrorist financing and propaganda, those weren't even considered catalog crimes under Article 133 at the time. It was only later that they were added to the list.
So the legal justification seems incredibly weak, at least according to the report. They even mention that a report from MASAK, that's the Financial Crimes Investigation Agency in Turkey, didn't back up the money laundering claims.
Yeah, that's a crucial detail. The Massac report was supposed to be one of the pieces of evidence justifying the trustee appointment, but the report we're discussing says that it didn't actually identify any underlying criminal offenses. And that's a problem because without an underlying offense, you can't really make a case for money laundering.
So they went through all this trouble gathering tons of data, searching computers, going through records, but they still insisted that they needed to appoint trustees to uncover the truth. Does that make any sense?
The report raises that question directly. They had all this data already. Why did they need to go to the extreme of appointing managing trustees? These are people who completely take over the company. Why not just appoint supervisory trustees who would have a much lighter touch? It really makes you wonder if the real goal was something other than just finding evidence.
And the people appointed as trustees for Kaynak Holding, did the report have anything to say about their qualifications or whether they might have been biased?
That's another point of concern. The report notes that one of the trustees, Aytekin Karahan, had previously been accused of being involved in bid rigging. So there's this question of whether these people could really be impartial and manage the companies fairly.
And right after the trustees were appointed, what kind of actions did they take? Did they seem to be focused on preserving the company's value and keeping it running smoothly?
There are some actions they took that raise red flags, like they immediately removed any books written by Fethullah Gülen from Kaynak Holdings stores. And they ordered the printing company to stop printing those books altogether. These moves clearly hurt the business. They also fired a bunch of employees and forced the general managers to resign. This kind of disruption definitely didn't help the companies.
And in the end, what happened to Kaynak Holding? The report mentions a confiscation ruling.
Right. Despite the fact that the initial justification for appointing the trustees was pretty weak, Kaynak Holding and many of its companies were later hit with a confiscation ruling by a court in Istanbul. That decision was upheld on appeal, and it's now waiting for a final ruling from the highest court. It just goes to show how long this process can drag on, and how the owners can be deprived of their property for years, even without clear evidence of wrongdoing.
So we've really dug deep into this first report from the Systematic Violations of Property Rights by the State in Turkey series. Specifically, we've looked at the appointment of trustees to companies. And it's a pretty disturbing picture. The report argues that legal frameworks were misused, that the economic impact was devastating, and that basic principles of fairness and due process were ignored.
Yeah, and remember, this all happened against the backdrop of alleged ties to the Gülen Movement. The report really highlights how that label was used to justify actions that might not have stood up to legal scrutiny otherwise.
The case of Kaynak Holding is a perfect illustration of that. It shows how politically motivated actions can have a huge and lasting impact on businesses and individuals.
And this is just the first report. It lays the groundwork for understanding the broader project, which is about documenting these violations and trying to find a path to justice.
It raises some really important questions. What happens when economic power and the legal system get intertwined like this? What are the long-term consequences for a society when the lines between political goals and the rule of law start to blur?
These are things we all need to be thinking about. Until next time.